What does a fair trial really mean? Is it about rules followed, outcomes achieved? Or is it something deeper? Something we only recognize when it's missing? Two former bankers, accused of rigging interest rates, condemned as financial criminals. A decade later, their convictions are overturned by the UK's highest court, revealing not justice, but systemic failure. Then, Justin Plummer, convicted of a brutal murder with no physical evidence, twice. Freed only after 28 years, thanks to a discredited expert and a dead cellmate's word. And now, sweeping reforms to how evidence is handled in sexual offence cases. The Law Commission has weighed in, but are we balancing fairness or tipping the scales? This isn't just about trials gone wrong, it's about the future of justice. We will walk you through two powerful case studies, a major reform proposal, and ask the question that matters most: are we still getting it right?
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we are digging into a vital question. What does a fair trial really look like? And are we getting it right? Rather than answering the question for you, as always, we provide you with case studies so that you can make your own mind. As usual, my recommendation to subscribe to this channel if you haven't already, and like and share the content to help us with our mission to humanize the criminal justice system. Let's start for once with some long overdue good news. After years of legal battles, the Supreme Court has finally declared the convictions of Tom Hayes and Carlo Palombo unsafe. In a powerful judgment handed down on the 23rd of July 2025, the court didn't pull any punches. It opened with a striking statement. The history of these two cases raises concerns about the effectiveness of the criminal appeal system in England and Wales in confronting legal error. That's quite the opening, and it sets the tone for what follows. But before we dive into the implications, here is a quick recap. Tom Hayes was convicted back in 2015 for allegedly rigging LIBOR rates. He was sentenced to 14 years, later reduced to 11, and served about 5.5 before release. Carlo Palombo was convicted in 2019 of a Euribor and served 2 years of a 4-year sentence. If these cases ring a bell, that's because we covered them in several videos, and in particular in this video linked in the description below. For those of you who do not know what rigging means, let's break it down. Imagine you are applying for a loan and the interest rate you are offered depends on a number called LIBOR or Euribor. Basically a benchmark showing what banks charge each other to borrow money. But here is the twist, and there is always one. That number wasn't set by a computer or an algorithm. It was based on what traders at big banks say they thought the rate should be. In other words, it was partly based on opinion. Some traders figured out, or in fact were even directed, that by slightly tweaking their submissions up or down a set of scale, they could help their bank make more money on trades. That's what's called rate rigging, adjusting the numbers to benefit certain deals. At the time, this was commonplace in the industry, not exactly transparent, but not illegal either. In fact, many saw it as just how the system worked. The scandal erupted when authorities began prosecuting individual traders for fraud. even though governments and central banks may have been doing something very similar behind the scenes, which is what some think actually caused the market crisis. According to financial journalist Andy Verity, whose book titled Rigged shed light on the deeper story, prosecutions such as those of Tom Hayes and Carlo Palombo by the serious fraud office were a distraction. The real scandal, in fact, involved a practice known as lowballing. That is interest rate manipulation, allegedly ordered by central banks and governments themselves. That evidence, however, was kept out of court. Instead, attention was steered toward rate rigging, a practice that, while widespread and market-driven, wasn't unlawful at the time. More importantly, traders like Hayes and Palombo didn't see what they were doing as dishonest. It was quite literally business as usual. In both trials, the juries were directed that any consideration of trading benefit rendered the submissions dishonest as a matter of law, effectively removing the jury's ability to assess the defendant's state of mind. However, the Supreme Court ruled unanimously that the trial judges misdirected juries by not letting them decide the key question: did these traders honestly believe the rates they submitted were accurate? That question was never properly put to them, and for that reason, the convictions could not stand. Genuineness and honesty must be assessed by the jury based on subjective belief, not judicial assumption. This might have been good news if only the story ended there, but it didn't. The Supreme Court didn't stop at declaring the convictions unsafe. It went further, asserting that there was ample evidence that could have led to convictions. In doing so, it arguably overreached. Relying on the very evidence presented in trials, it deemed unfair, a move that, in our view, undermines its own credibility. Rather than speculating on the strength of the evidence produced in a trial deemed unfair, the court should have simply declared the convictions unsafe and refrained from commenting further on the disputed evidence. The prosecutor's decision not to order a retrial, along with the Financial Conduct Authority's subsequent withdrawal of proceedings and lifting of industry bans against Hayes and Palombo, may be seen as tacit support for Andy Verity's argument that the real market manipulation crisis originated higher up the chain and that a retrial might have exposed uncomfortable truths about central bank involvement. But where does this leave Hayes and Palombo? Once again, we are faced with two individuals exonerated in principle, but denied both justice and redress. With no retrial, no compensation, and no official acknowledgement of wrongdoing, they remain burdened by stigma of being cleared on a technicality, not vindicated by truth. It raises a troubling question. If our justice system cannot provide closure even when it admits fault, then what exactly is delivering and who is it really serving? We hope that Carlo Palombo and Tom Hayes can find the strength to move forward and the peace they deserve despite the injustice they endured, both at the hand of an unregulated workplace and a criminal justice system too quick to assign blame. On second thought, perhaps that wasn't such good news after all. Let's turn to our second case study and ask, Does this bring us any closer to a helpful answer? Because remember, the heart of today's question lies something fundamental. What really makes a trial fair? This is another overturned conviction, this time by the Court of Appeal. But to understand its significance, we have to go back to the beginning. Justin Plummer was convicted in 1998 for the brutal killing of Janice Cartwright Gilbert during a robbery. As usual, we take a moment to remember the victim, to pay her respect. The details were horrific: stabbing, stamping, and then setting fire to a mobile home. But here is the striking part. No physical evidence ever linked Plummer to the scene. No DNA, no eyewitnesses, no stolen items recovered. Instead, the prosecution's case hinged on a so-called expert. Again, expert evidence, here we are. A dentist turned forensic analyst who claimed that a trainer mark on the victim's head matched Plummer's shoe, using a method that had never been scientifically validated. That so-called science was later discredited, and in 2021, Plummer's conviction was overturned. A retrial followed, but in 2023, he was found guilty again. This time, the prosecution leaned heavily on an alleged confession made by a fellow prisoner, Christopher Dunn, a paid police informant who died in 1999. No cross-examination, no scrutiny, just the word of a man who was no longer alive and whose motivations could never be tested in court. On the 30th of July 2025, the Court of Appeal had seen enough. Lord Justice Edis, Mrs. Justice McGowan, and His Honour Judge Lickley KC ruled that Dunn's statement was inherently unreliable and deeply prejudicial. It should never have been admitted. Katie Thorne KC, who represented Mr. Plummer, said this has been a 28-year fight for justice. Permitting a dead cell confession witness in a trial on an allegation of this age was simply unfair and should never have been permitted. Prisoners have all sorts of motives to give false cell confession evidence, and law reform is needed to stop such evidence being part of criminal trials. Now Justin, a man who has suffered this miscarriage of justice for nearly 30 years and who was incarcerated before iPhones or electric vehicles or even household laptops were in existence, is now being released with little support from the state. The system has to be reformed to give proper support to such victims of miscarriage of justice. Annalisa Moscardini of TBI Scanlan's solicitors, who has represented Justin since 2016, has worked so hard and for many of the last 10 years unpaid. She and Peta-Louise, whose extraordinary work was beyond compare, have made all the difference in this case. Without their incredible work, Justin's conviction would never have been quashed. So, is this really justice? Is this good news? Were his trials ever truly fair? That's for you to decide. But remember, it took a CCRC application, 2 appeals, and 2 full trials before Plummer finally walked free. And even now, justice for him feels more like survival than victory. His case may not have involved a sexual offence, but it raises a critical issue that echoes through the Law Commission's latest reform. How do we design trials that support the complainants without tipping the balance against the accused? Let's take a closer look at the 72 reform recommendations from the Law Commission's final report, Evidence in Sexual Offences Prosecutions, published on the 22nd of July 2025. It's a substantial piece of work, and I'll be honest, I haven't had the time yet to fully digest every detail. A more in-depth background will come later as our Your Voice Matters podcast gains momentum. But for now, I'd like to share a few initial thoughts, particularly around what these reforms mean for the fairness of criminal trials. First, the report is said to be a direct response to the government's 2021 end-to-end rape review, which claimed there has been a significant drop in rape prosecutions since 2016. But as we have discussed in a previous video, linked in the description below, we are not entirely convinced by the foundations of that review. Why? Because the research of Professor Cheryl Thomas directly challenges two of its central assumptions: that juries are reluctant to convict in rape cases, and that juries are heavily influenced by rape myths and stereotypes. In fact, Professor Thomas' findings suggest juries are more likely to convict than acquit in rape trials, and that the supposed impact of rape myths in the courtroom may be greatly overstated. So, if the report is responding to a flawed premise, we should be cautious about how far its reforms go. Here is a simplified overview of the key proposals of the Law Commission. First, mandatory training for all legal professionals in sexual offence cases, including judges, prosecutors and defense lawyers, to better understand trauma, consent and myths like real victims always fight back or delayed reporting means lying. Clear jury directions. Judges must explain that people respond to trauma in different ways, that not resisting isn't the same as consenting, and that a complainant's past sexual history doesn't prove anything. Tighter rules on accessing private records like therapy notes. Judges would weigh up the value of this evidence for the defense against the complainant's right to privacy and dignity. Stricter limits on sexual history evidence. Claims about previous sexual behavior or compensation motives should only be allowed in if absolutely necessary and not prejudicial. Independent legal advice for complainants before decisions are made about whether their private records or past behavior can be brought into court. Automatic protection for complainants, like giving evidence by video link, behind a screen, or via pre-recorded interviews without having to justify the needs. Specialist sexual offences courts with trauma-informed staff, better scheduling and more consistent handling of these sensitive cases. Penalties for inappropriate defense tactics and tools to prevent myths from contaminating what the jury hears. Allowing expert input in complex cases to help juries understand the psychological impact of sexual harm and how victims may behave. Now, here is where things get complicated. A criminal trial's core purpose, as we know, is not to secure a conviction. It's to make sure that only the guilty are convicted and the innocent walk free. That That's why we have the presumption of innocence, the burden of proof resting with the prosecution, the standard of beyond reasonable doubt, the right to a fair process and legal defense. If we start reshaping trials to heavily center on the complainant's experience, giving them legal representation, rights to challenge what evidence get in, and extensive protection, we risk drifting towards a civil-style model where the complainant starts to look more like a party in the case rather than a witness. And that comes with dangers. Too much focus on trauma might lead juries to prejudice the accused. Limiting cross-examination could exclude key facts. Training judges and lawyers in myth-busting could create a bias in disguise. The Law Commission recommends keeping juries in sexual offences trials, rejecting both judge-only alternatives and the idea of requiring jurors to explain their verdicts unless strong evidence demands reconsideration. But this position feels at odds with the concern that the jury may be swayed by myths or stereotypes. It raises a deeper question. If those concerns aren't enough to justify structural change, perhaps this reform isn't really about tackling myths and stereotypes after all. We are not saying these reforms don't have merit, but are these changes compatible with the fundamental role of a criminal trial? If we want to rethink the model entirely, that's fine, but let's have that conversation openly. Let's not quietly rewrite centuries-old principles under the cover of a reform. In short, if a trial's aim is to prevent wrongful convictions, we must be extremely careful not to tilt the scale so far that we undermine that goal, no matter how well-intentioned the reforms may be. We started with a simple question. What does a fair trial really look like? And are we getting it right? The answer isn't easy, because fairness lives in a tension between competing imperatives, protecting the innocent from wrongful conviction while ensuring victims can be heard without being re-traumatized or misrepresented. From Hayes and Palombo, we saw how a conviction can be undone because the process misdirected the very people, juries, who are supposed to decide intent. From Justin Plummer, we witnessed the human cost of shaky, untested, and unfairly admitted evidence. Decades lost and freedom won only after exhausting appeals with no real closure for the victim's family. And the Law Commission's report reminds us that reforming how evidence is handled, especially in sensitive cases, can protect complainants, but must be calibrated so that it doesn't inadvertently erode the safeguards that keep the system truthful. So what makes a fair trial? Maybe it isn't a single rule or reform. It's a system that demands clarity and honesty in how evidence is presented. A system that trusts the jury to decide on subjective intention without shortcuts. A system that guards against prejudice, but it still shields the innocent when the process itself fails. We have given you the evidence, flaws exposed, reforms proposed, lives affected. Now it's over to you. Is justice being served or just adjudicated? Let me know in the comments below. This concludes our discussion today. I hope that resonated with you, and if it did, remember to like, share and subscribe, and of course join us again next week as we sit and rise in this unique trial.